Licensed entities. Again, this is another protocol that is very common amongst the regulated industries that we deal with. It sets a protocol up for reporting requirements for various entities at both the local and state level. The only question that I had rereading this again last night is whether or not local government wants the background side of stuff and to what extent. Knowing that the state has the mandate to do the background investigation, to what extent would local government want information?
Well, and that's as an overall issue, and Dan and I have talked about this briefly as well, when it comes to licensing, or in this case transfers and stuff like that, but particularly with licensing in general, since the local licenses, applications are filed with the local licensing authority. Let me back up. Since the applications are filed with the local licensing authority first, there becomes this question of what would they be approving if they are not, and it's something we missed in 1284, they don't have the ability like they do in the liquor code to do CCIC criminal background checks. And in the liquor code, local governments, local licensing authorities do a tremendous amount of work up front on background. Many of my members want to do that. So as a separate matter, as a legislative issue, that's something that might have to be dealt with. But the answer to your question is yes. I think that I know that when it comes to the background stuff, the local governments want to be included on that. And when we get to the licensing portion of it, since the application has to be filed locally first, we've got to figure out how to deal with that, because not that there's any trust issue whatsoever, but I don't think that a local licensing authority is going to approve a license for which they don't know the background of the applicant.
No, and I agree. My concern at the state level is whether or not a license has been surrendered or canceled, right, and the check and balance that local authority needs to provide there. You would still need to approve it. We would still need to do the suitability determination. I'm trying to think. There may be issues concerning the usage of the premises, the history of violations, a number of things that the local authority, they may be set for a show cause hearing, a denial hearing upon renewal, a number of things that need to be addressed at the local level. And my concern was if I set this protocol up to require the state licensing authority to do the backgrounds and all those kinds of things, not knowing what the local issues are on the front end, knowing that the statute requires the local government to first approve it before it comes to us. Right? That's really the protocol. The concern I had, or the question was, whether or not the background documents, because of, again, the way 1284 is configured today, is there a need for that information to go to local government?
I think their answer is yes.
Ed?
I would say that some would say yes. I wouldn't say they all would say yes, because I'm a trustee in Lions, and our PCDC is looking to address only things like zoning and not get into background checks and things like that, the cost associated with that for such a small town. And so they would figure that process would get vetted out on the state level when the application was submitted to the state, because they need both in order to stay in business. The redundancy adds cost to both the licensee and the board that's empowered to do that. So I would just like to put that caveat in that not all.
I agree with that. I think the majority of the 1900 applications that you got, the majority of them are in municipalities that are going on to, but I agree with you. It's, especially for small towns, it's a huge expense, and so there needs to be ability to.
Is this something perhaps we would require passage of a local ordinance or resolution, or upon local request? Do you know what I'm saying? An applicant shall submit, or licensee shall submit copies of the background form so that it's venue specific.
Are we talking just in for this particular rule? I'll get back to you on that.
I would suggest that maybe all the documents that are the product of the state get returned to the local so the local has a record of all the rest of the documents.
Well, potentially, the local authority could issue a conditional license based on satisfactory meeting of all state requirements.
Yeah, the issue is they're not gonna know until after the fact, and the statute does prohibit the issue of the license without the state license, so. Thought?
Matt, as you know, this rule is different than the liquor code rule that I've been familiar with, and I think there's some structural problems the way it's worded, and here's what I mean. It talks about a transfer of stock or membership interest or partnership interest having to be reported prior to the transfer. But the language says any transfer has to be reported 30 days before the transfer. So it doesn't quite make sense. It should say any proposed transfer. Okay, not that that's a big deal, but here's the other, what I think is more confusing. If you report the transfer 30 days prior and you hear nothing from government, does that mean it's approved?
No, it doesn't. I mean, the statute clearly requires the issuance of both the state and local license to be approved.
No, and I understand that, but the license wouldn't change a bit. What this rule contemplates is, well, in part, let's say there are two people in my LLC, you and and I decide to buy you out, and and replace you with another person. If I report that, the license isn't changing a bit. License remains the same, as you know, but what happens to my new partner? If I report it 30 days in advance, and we have to have a closing after that 30 days, do we proceed with the closing, or do we wait for an official notification that my new partner is now approved? I think that's where it gets into it.
I hear your concern, and I'm going through my mind trying to figure it out, because as you know, some structures are much more complex than others, and
Right.
some require, a very simple check, and others take a very long time. My concern is, and I acknowledge your concern, but I don't know how we create a protocol that, for example, pick a time frame, 30 days, 60 days, whatever it is. If I do that, and then we don't have the ability, we're waiting on records to come back from another entity or something. Do you see what I'm saying? How do we?
I do. It's almost like issuing a temporary permit. As you know, like a complete change of ownership of a liquor license, you can ask for a temporary permit, and within 5 business days, you can basically get in there and start operating under the new ownership. This leaves the status of the new member or stockholder or partner somewhat up in the air as to whether they can actually pay for their stock or their membership interest, and when can they pay.
And I believe what you're referring to is actually addressed in the statute.
Okay.
But off the top of my head, I don't know which one it is. But I believe it says that it's unlawful to have the interest
To acquire an
unless they've
interest.
gone through the background investigation.
Right, and that's why I think this rule may need to be modified in some respect, because it almost assumes that once you present this proposed change 30 days in advance, if you don't hear anything, do you proceed? Do you not proceed? What's the reason for the 30 days? Maybe you want to take it out.
Sure. Time frame of 30 days, yeah.
Yeah, because if you're really waiting for ultimate approval of the background qualification, if you will, of the new member stockholder, then why bother with 30 days?
You have a valid point.
Yeah.
I was really just trying to give the industry some guidance.
Right.
And
Because
it
it's
is
much like the gaming rule, I think now.
Exactly.
You're,
That's
right.
correct. Okay, Jessica?
I guess this brings up the question to me as, is this person, this, hypothetical new partner for a business like Bob's, when does that person begin their background check process? Do you begin the background check process at that 30 days of notice prior to any exchange? And how would that be handled if hypothetically Bob's original partner, rather than being bought out, died?